Turns out there are some common law principles floating around that have that kind of symmetry that the 19th century, 18th century common law loved. If it's good for one party, it must be good for the other party. It's all symmetrical and everybody's happy. Well, in reality, it doesn't make a lot of sense to me. That if you have a principal who is liable both, and as in this case, both vicariously and directly liable, and you let that principal go, why in the world should the agent be released? You get an echo of the common law in the de Graaf opinion, which is distinguishable because it talks about there has to be a ground equally applicable to both. So I suppose if the sole liability here for Walgreens was vicarious liability, maybe you would have a ground equally applicable to both. And de Graaf, the statement in de Graaf might apply. Of course, de Graaf and law and these other cases deal with releasing the agent, not releasing the principal. So you've got sort of a half-dicta statement being made in de Graaf. They didn't really need to say, well, this is the general common law rule. They should have said the specific common law rule that controls here is if you release the agent and the liability is vicarious only for the principal, then you release the principal as well and be done with it. But instead, they floated out the other idea. What troubles me about this case is not so much this case, although I'm deeply concerned that there be justice in this case and we get it back on track and have an actual trial to judge the janitor's liability. What troubles me more about this case in a way is what's the next case when the only liability for the principal is vicarious liability. And you've got these common law fragments floating around. And I don't know how the court addresses that.
Well, we don't need to address the common law, I suppose, which is interestingly developed across the country, although not here, if there's a statute that applies. Why doesn't 122504 apply here? And does it apply here? And before you answer that, tell us, is there a settlement agreement in the record that we're missing?
Yes, you are missing it. The actual terms of that agreement are not in the record.
But there is, do we know, is there an agreement other than, is there a document somewhere, or do you even know that?
I know it, and there was indeed a document, but it is not part of the record.
Okay.
And yes, ARS Section 12, 2504 would apply. And that's very, very straightforward. In a comparative fault system, it makes a lot of sense. And basically it says, if in good faith you have a release or covenant not to sue or not to enforce a judgment, then that doesn't discharge the other tortfeasors. There can be a pro rata reduction in whatever has to be paid, but that's all the effect is, which makes sense if you're dealing with a comparative fault system.
Well, even though not in a comparative fault system, I was interested to see that there are a couple of cases from the mid-90s, Rowland and another one, which make the point that what's up with 2504 in the comparative fault? Because Arena and Rowland makes the point that 122504 applies not in a comparative fault situation, but in the joint and several liability system, and what used to be our world, and I wonder if that's the case. That's what we have here: joint and several liability, because of the vicarious liability, because of the
right.
So if then maybe this is the case, by contrast to law, where the remaining defendant was not the tortfeasor. Maybe this is the case where 2504 does apply because the remaining defendant is the tortfeasor, is the joint and severally liable tortfeasor.
I've run across the case law that deals with 122504 before. In fact, I got into a discussion with Justice Feldman about this one time. We had another case. He said, well, 122504 doesn't apply here. I said, but it's plain terms. It should apply to every comparative negligence case, and I believe that it does, and it would apply to this particular case. Whether you call it joint or not joint. I mean, the joint part comes in from 122506. It has that definition, well, 122506, subpart
Yeah,
D.
D.
D2, or D1 for that matter. Acting in concert is D1, and D2 is acting as an agent or servant of the party. But that's hedged around. If you take a look at the first part of D there, it says the liability of each defendant is several only and is not joint, except that a party is responsible for the fault of another party or for payment of the proportionate share of another party. So if you're talking about payment of a proportionate share, that's really throwing you back to 122504, where you are indeed paying a proportionate share.
Except the 122504 doesn't talk about proportionality. But be that as it may, why can we, the other side says, well, without regard to this somewhat esoteric discussion that you and I have been having, 122504 doesn't apply because there's no release here. What's your answer to that? There's no release. What we have is a judgment with prejudice.
Well, you've got a judgment. The reason you've got a judgment with prejudice is that there was an agreement to do that, which is a release or a covenant not to sue. I don't know the exact, I can't recall the exact details, but it's a release. I mean, if you've got this judgment with prejudice that is founded upon an agreement to drop the case, then you've got a release.
Because is the argument that is your contention that the judgment is in effect a release? It has the effect of a release because it's with prejudice. The claim cannot be brought again.
You could look at it that way, or say it's a memorialization of the release, or it is the outcome of the release, or it is the effect of the cause, which is the release. In other words, the end result is that you've got something goes on before. This isn't an adjudication of any kind. This is simply there's an agreement to let Walgreens out, and then what happens is this judgment with prejudice is entered. I have, yes, the other point I wanted to discuss briefly is the restatement third, which troubled me a great deal and still does. But if you read the two sections of the restatement third of apportionment together that have been discussed, comment D to section 16, comment J to section 7, if you read them together, they only go into effect when a person's liable solely on the basis of another person's tortious conduct. In other words, you've got to have that, and as far as this situation is concerned, you've got to have that vicariously liability as the sole basis. And so we have it here, and these sections of the restatement don't affect the result that we're asking the court to approve, which is to say that releasing the principal does not release the agent. I could chat forever in a vacuum, but if there's no further questions right now, I'll reserve my time. Thank you very much.
Thank you, Counsel. We will then hear from the amicus. Give us just a moment while we endeavor to reset your clock, Counsel, so you're not working on bad information. How about that?
It's like we're at a basketball game.
All right, thank you. Mr. Altus, is that?
That's it, correct.
Very well, please proceed.
May it please the court, my name is Scott Altus. I'm with Fenimore Craig, and I'm here on behalf of the amicus Banner Health. This case is about the fundamental distinction between the imputed or vicarious liability of a principal versus the direct active liability of an agent who himself or herself harmed a plaintiff. The trial court's ruling in this case treated those two distinct categories of liabilities as equivalent, but they aren't equivalent, and they should not be treated as equivalent when evaluating and defining the effect of a settlement with one and not the other. Judge Johnson, I want to pick up on your point regarding 122504. Absolutely, that statute applies, and we're not alone in the dark on this issue. There are a number of cases, and we've cited a number of cases in our amicus brief, that analyze the identical statute in this identical situation. And what they say is that there is a difference between the first prong of that statute and the second. That statute says when one of two or more parties liable in tort for the same injury, when one of those are released, it does not discharge any other tortfeasors. Well, those cases say that there is a distinction between the first part of that, one of two or more parties liable in tort for the same injury, and the second part, which is tortfeasors. The actively negligent agent is a tortfeasor, but the purely vicariously liable principal is not a tortfeasor. So that statute answers the question. It says that when you have a principal who is released, it does not have the effect of discharging a tortfeasor. An agent, the actively negligent agent, is a tortfeasor. And there are a number of cases that hold exactly that. Hatcher, Smith, Vanderpool, several others that we've cited in our amicus brief, applying the identical statute to the identical set of circumstances. Now, I don't know, as not having been a party to the case, the issue that you raised, Your Honor, regarding the existence of a release. I certainly assumed that there was a release in this case, and I think your point that in effect, what happened released the liability of Walgreens in this case. But I've never had a case settle where you didn't have a release. So I assume that there is a release here and that 2504 applies. If for some reason it doesn't apply because there is a release that isn't in the record, I would suggest that the court needs to be very careful how it rules to make sure that whatever ruling it issues, if that's determinative, is limited to that, what I would think would be a very unique circumstance where there's a settlement but no evidence of a release. I also want to discuss DeGraff. DeGraff is a 1945 case. DeGraff is really the only basis for what the trial court ruled and the only basis for what Appley is arguing here. If you look at the discussion in DeGraff, it's one line in that decision that we're talking about. And that one line isn't even the court's own words. It's part of a very long, almost a full-page block quote, not even from another case, but from an even older legal encyclopedia, Amger. And the issue that was at issue in DeGraff isn't our issue. It had to do with the effect of a release of, or dismissal of the agent, and what effect that had on a claim against the principal, not the reverse.
And counsel, I understand your position that DeGraff is factually distinguishable and that legally it is based on things other than case law of this state. What else, though, as far as case law in this state, do we have to go from?
Well, there's no case law that addresses our issue. We are bringing an issue of first impression to you in terms of the effect of a principal, of a release of a principal on the claim against the agent. The other cases that have addressed this universe of issues all follow the same fact pattern as DeGraff. It's what is the effect of a release, a dismissal, et cetera, of an agent on the claim against the principal. And of course, if you think about it logically, if you think about it as a chain, you've got the plaintiff, you've got the actively negligent agent who acted upon the plaintiff, and then over here you've got the principal who is only derivatively liable. If you take the principal or the agent out of that equation, there is no connection between the principal and the plaintiff. That's very different than if you take the principal out of the equation. It's a fundamentally different scenario.
Let me ask you, and I understand that factually that is different, and I understand that DeGraff addressed kind of the flip side of this case, but the restatement third of torts regarding apportionment of liability appears to, at least in some respects from my reading, to treat those two situations the same.
And to be honest, Your Honor, the restatement is itself conflicting. If you view the restatement as a single collection, and it really isn't, but if you viewed it that way, the restatement of judgments has language which indicates the exact opposite. It indicates that a dismissal based upon a settlement is not a judgment on the merits. It indicates that you are free to settle with one party without affecting your claim against the other. That's in the restatement of judgments and the restatement of torts. And I do agree that the apportionment of liability provision is in conflict with that in the commentary. I mean, it's just in the commentary that the appellees rely on.
And it's not the black letter, conceitedly, but the commentary is absolutely inconsistent.
I agree.
At least in a sliver of cases.
That's absolutely right. And the other issue that I want to highlight are the policy issues that we've talked about. It's in the briefs. There's obviously the standard policy consideration of you want to do everything to encourage settlement. But also, I think there's an even more fundamental policy issue here, which is that the trial court's ruling and appellee's argument would essentially allow the actively negligent party to evade liability. That's contrary to the foundations of the tort system, and I want to highlight indemnity principles as an example of that.
Let me, before you do that, because
Sure.
you're the one sort of entity here that is not a party, and I have
Right.
one follow-up question for you. With respect to actively considering, or actively encouraging resolution short of trial or additional litigation, I understand what you say. Isn't a rule that requires the settlement to say, yes, this does include the agent, no, it doesn't? Isn't that one way to work through this that would sort of, you would never be here if that had happened here?
I agree, although there is language in case law that suggests that even if you preserve your claim in the context of the release of the agent, the fact that that releases the principal, there is at least the Mann case, which is a Arizona Federal District Court case, that says it doesn't even matter if you expressly reserve the claim against the principal. Once you release the agent, you've again broken that chain. If the court wanted to hold that as long as you are expressly reserving your claim against the agent when you release the principal, that that's effective, I wouldn't have a problem with that. But if that's the ruling, it needs to be clear, because the concern, what brought us here as an amicus, is the concern that we face when we're attempting to settle a case. While this case here is pending, we're hearing anecdotally from plaintiffs who we are dealing with, I'm worried about trying to settle with you because I'm worried that if I settle with you, the physician who we're claiming is your agent and we're claiming is not our agent, they're going to argue that the claim against the physician is now barred. The concern I have is that that's going to continue if there isn't a clear definition of what the law is. And that's really why we wanted to participate in the argument, is to make that clear, because we are hearing that in cases that we're actively defending right now, that exact issue. And with respect to the policy issue that I was raising, the allowing the actively negligent party to escape liability, with respect to indemnity principles, I think that illuminates this issue. In a vicarious liability context, the law is clear that if a principal is held liable purely for the vicarious liability of their agent, that principal is entitled to seek indemnity from their agent. That reflects the law's idea that as between the actively negligent agent and the vicariously liable principal, the ultimate liability should rest on the negligent party, not the derivatively liable party. And the trial court's ruling here is inconsistent with that. I've got about a minute left. If there are no questions, I'd like to reserve that time.
Very well.
Thank you.
Counsel. Let's hear next from counsel for appellant, Mr. Doman.
Thank you, Your Honor. May it please the court. My name is Eddie Doman, and I represent the Appellee American Floor Care. I think one of the tough things, or what makes this case interesting, is that you're dealing with 3 or 4 different sort of principles of the law, and it's easy to let one bleed into another to make things look in a way different than they are. For instance, you mentioned that the restatement makes it clear that in this situation, what we're working with is a single entity, and if one link in this chain gets released, then liability against the other one is gone. I don't believe the restatement on judgments, comment F, is inconsistent with that. I believe that's dealing with a totally different issue. That issue is what effects do dismissals with prejudice have? So under the restatement view, so when you're looking at it from Arizona, it looks like it's conflicting with a restatement saying this would happen here but not there. But the difference is Arizona has long held that they treat dismissals with prejudice different than the way a lot of states do, including the states that were cited into their briefs. In Arizona, over and over again, it happened in law, it happened in Torres, they say when you do a dismissal with prejudice, it is a judgment on the merits which has certain preclusive effects. So Restatement 51, comment F, isn't inconsistent with the other section. It's dealing with a different issue that Arizona has made clear that it goes against that comment based on the manner in which it treats dismissals with prejudice.
But, so what you're saying is that that Arizona cases have rejected Restatement of Judgments 51?
I believe as it relates to comments E and F, they have by consistently holding that a judgment, regardless of if it was by consent.
Although there's the Cheney case, which cited that,
Right. I believe.
generally, except in the DeGraff situation.
Well, exactly. Cheney didn't deal with vicarious responsibility. The more applicable case to look at is law, because the facts of law say that they reached a settlement and then entered into a stipulation for dismissal and a stipulation for a dismissal with prejudice. I would almost be certain that there was a release in law in addition to the stipulation of dismissal with prejudice. And I think that gets into the argument that we were just talking about as it relates to 2504. We're talking about how there's a release, and we're saying we could supplement it, and somehow that's important. Well, the way 2504 works isn't that if there's a release, that section of the restatement applies. The issue is that section is inapplicable to have the effect that statute was designed for when you have a dismissal with prejudice. The dismissal with prejudice, by being a judgment on the merits, trumps the application of 2504, which I don't believe it applies at all as it relates to joint and several liability and vicarious, because the cases have said over and over again that nothing about the Uniform Contribution Amongst Tortfeasors Act affected Arizona's laws as it relates to vicarious liability.
Well, okay, slow down, let me take a breath here.
Sure.
The 250, Rowland and other cases hold that 2504 applies after Ucata in cases of joint and several liability. So in the handful of situations where we have joint and several retained. 2504 applies not where there is a release or a covenant not to execute. Covenant not to execute on a judgment. Covenant not to execute on a judgment. So how is it that we can say that 2504 does not apply when there has been a judgment against a defendant, a stipulated judgment?
Well, I believe it's because in law that's exactly what happened.
Well, yeah, but it's just, but doesn't the language of 2504 necessarily cause us to conclude that it applies when there is a judgment? Because you can't have a covenant not to execute if there's not a judgment.
You can if the covenant not to execute is issued before the judgment actually exists, which is what can occur in a lot of cases. I think one thing to keep important is that the Uniform Contribution Amongst Tortfeasors Act, as Arizona drafted it, was based on the Uniform Act. Now, Arizona has some unusual laws as it relates to getting to pre-judgments. Morris, Damron, Helm, Peaton, all that sort of thing. The drafters of the restatement weren't necessarily considering that sort of a case, that issue. So I know because of those agreements that Arizona recognizes that in this particular state, you end up having judgments that exist before there is an actual judgment on the dispute. But in most states, I believe what the intent of the paragraph that you're talking about would be is in a situation where you have two defendants and one of them settles with a covenant not to execute. There's not an actual judgment yet. They still remain in the case. This isn't an uncommon practice in other states. And so they remain in the case with a covenant not to execute along with the other defendant. You end up going to trial where a judgment may very well be entered against them for some reason, if nothing else because of cross claims or whatnot that are brought by the other defendants. And what the case is saying is that the simple execution of a covenant not to execute before there is a judgment doesn't let that other party get out before the case reaches its ultimate final conclusion of a judgment. So I know we're unique in Arizona in that you end up seeing a lot of judgments that happen before a case is ultimately all the way done, but I think that's where the distinction or the concern you have about a covenant not to execute affecting judgments comes from, because I believe in most situations, in most states, when you have a covenant not to execute, what they're saying is that alone doesn't allow you to get out, by the execute of that covenant, not that a judgment trumps what the statute itself is saying. And so I think that's sort of where part of that comes in. I think Arizona's longstanding policy on the judgment being a judgment on the merits is really dispositive
Although it's a judgment on the merits of the, against the settling defendant.
Right.
It's a judgment on the merits that that in this case Walgreens has no liability. But I'm not sure that 2504 allows us to conclude that judgment on the merits affects the liability of the tortfeasor. Because this is not a law situation.
Right. Well, and I understand what you're saying with regards to the applicability of 2504, but I think the concept to keep in mind is how all of this works from a common law perspective. Now, 2504 changes the common law in that in the situation that it's talking about, it lets you release someone and then you get credit for the deal. Again, I think a judgment trumps that concept. And so in this case, because of Fort Lowell, nobody disputes in this case that Walgreens has a non-delegable duty. So the action against Walgreens is really two things. You have the action for Walgreens independent negligence, and you have the action against Walgreens that is based on the alleged negligence of my client. The dismissal with prejudice did not merely get rid of this claim over here that was for Walgreens independent negligence. If it did, if they hadn't made that claim in the first place, and if they had only litigated Walgreens independent negligence, then I would agree with you that it wouldn't eliminate the negligence of American Floor Care. But in this case, they sued Walgreens not only for their independent negligence.
Okay. Does that matter that there are two claims against Walgreens?
I don't believe so.
Yeah, okay.
I think the fact that, which is my point, because there was a lot of discussion earlier on the idea of a ground equally applicable to both. And what I'm saying is, on this second claim that's against Walgreens based on the actions of my client, the ground equally applicable to both is the alleged negligence of my client, which under Arizona case law is unquestionably attributable to Walgreens by virtue of the non-delegable duty. So I'm saying exactly what you just said. The fact that this other claim exists is irrelevant to me.
If 122504 applies to this case, must we reverse the judgment?
No, I don't believe so, because I believe the effect of the dismissal with prejudice trumps what 2504 is saying can happen if you only have a release or a covenant not to execute.
So you're saying that 2504 does not apply where the judgment that's not to be executed on is a dismissal with prejudice?
Correct. Right. Because I think the court's made clear that.
But how else? I mean, the context of 2504 is a settlement, a scenario in which the plaintiff has agreed with one of several tortfeasors to settle, resolve the liability. How else is that going to happen effectively without the plaintiff agreeing to a dismissal with prejudice?
Well, the case could be dismissed without prejudice and in conjunction with your release.
Without prejudice? Is
Right,
that
because
going to happen?
I think it will, because the release itself would fully protect the defendant. I mean, the release itself that's dismissing all claims, the judgment with prejudice is an extra step that's not even necessary. I mean, people settle cases before lawsuits exist all the time in exchange for just a release. And then if a claim is brought, that release is the reason that it has to get dismissed. And so I believe a dismissal without prejudice is applicable. I know we cited to the case where someone did bring a late claim under the statute of limitations, and then they ended up dismissing it without prejudice because they were concerned of this effect. And the court even mentioned the effect. Go ahead.
No, please. Let me ask you this hypothetical, though. So what if instead of what was filed here, there was something akin to a statement to the court, pursuant to a release, the parties have resolved these claims?
Yes.
122504 apply then, from your perspective? And,
Well, can I answer it in two ways?
Well, let me add one more thing, okay? And then it says, and please enter this order dismissing with prejudice. So otherwise, everything's identical to what happened in this case, but that word release is used in something that was filed in the court.
I believe that the court has said, in Wiggs and in other cases that 2504 doesn't apply to vicarious liability claims, period. So I don't agree with that premise because I think that law stands to the contrary. That said, I do want to go ahead and answer your question as if,
Yep.
so assuming that 2504 applied, then I don't think you could have a dismissal with prejudice. But if they did dismiss it without prejudice in conjunction with a release, then I believe that the way that the statute works, where you get an offset for the amount paid, that's what would happen. But from a practical standpoint,
So the answer is, if there was a release, but a dismissal, then the statute would apply, except that here there was a judgment with prejudice, which in your view makes the statute inapplicable.
correct. Once you assume 2504 applies to vicarious liability, yes.
Let me ask you a question.
Yes, Your Honor.
Would you agree with me that dismissal with prejudice means that they can't go after Walgreens anymore? Plaintiffs can't go after Walgreens anymore?
Yes, I
It's
agree.
a complete bar to the underlying litigation.
As it relates to any claim brought in the complaint, sure.
Okay. And then a release is also a complete bar to litigation.
Assuming it's properly worded, yes.
And so why isn't the dismissal with prejudice, which is a complete bar to litigation, moving forward on Walgreens, why isn't that considered a release? I mean, they're both complete bars to litigation, to
Right.
moving forward with Walgreens. Why isn't a dismissal with prejudice, I always get those confused, which is a complete bar, why isn't that a release?
Well, from a jurisprudential standpoint, it's a difficult question to answer. I believe it's clear in this state that the law is that the dismissal with prejudice has a specific legal effect, which is that it is considered a judgment on the merits, whereas a actual release that dismisses claims is not considered a judgment on the merits.
So I'm sorry, we're just having a hard time. It's not your argument. Your argument's very interesting, and you're expressing it well. It's just the concepts are difficult. What I hear you saying is even if there were a release in this case, the 2504 does not apply because the consequence of the settlement was a dismissal with prejudice. But in 4501 North Point, the Supreme Court held that issue preclusion only applies to issues that have been litigated, distinguishing the restatement of judgments 51, which talks about a judgment by consent that doesn't extinguish a claim against the person not sued. So I think that the point may be, and perhaps this was the point in law, a judgment by consent with prejudice is on the merits as to that defendant. In other words, a claim preclusion. But North Point held that it's a consented to judgment, or the teaching of North Point is that a consented to judgment is not a judgment on the merits, or it does not have issue preclusion effect.
When you're dealing with non-vicarious liability parties, I agree that that's the case. See, the idea with 501 North Point and with Cheney that we were talking about earlier, it deals with the idea of issue or claim preclusion, whereas if one issue was litigated between these two litigants and it's somehow applicable to the other one, then you're dealing with issues of whether or not you can use defensive collateral estoppel or whether or not it's somehow res judicata on that issue. What you weren't dealing with is a situation where you have the pure vicarious liability chain, which is what I think this court in the law opinion was getting at when they said this same argument, was made, and the court said it doesn't apply for two reasons. One, vicarious liability you're not joint tortfeasors, so the statute doesn't apply for that reason. And then it said the other reason was because we have a dismissal with prejudice, we're not just dealing with a release. And I believe both of those things exist here. And, you know, to further that point, I believe if what we're discussing and what we're talking about with regard to the restatement were true, then all of these cases where the vicarious liability ran the other way, like if we're just looking at that argument, then these vicarious liability cases that ran the other way would also have to be reversed. Because if what you're saying is correct and 2504 applies, then it applies also when you have the release of an agent and a remaining action against a principal. Then you should still apply that paragraph.
You might say that, and I guess you just did, except that the language of 24 applies to or speaks of the release of another tortfeasor. And perhaps the reason it doesn't apply is because in all these other cases, the defendant who's being released is not the tortfeasor, but the principal.
Well, and I understand that the states he cites to makes somewhat of a distinction on that background. I think it's somewhat semantics to say that someone who's liable in tort is not a tortfeasor. I believe, you know,
I understand your point, but that's what the cases say.
well, the Arizona case, no Arizona case has
that's-
ever said that.
Well, law came pretty close to saying that.
Well, but they said it for my other proposition that you shouldn't apply 2504 at all.
And I understand, and even then, in the reverse of the factual pattern that we have here.
Right. No, I understand it, and that's what makes this case so complicated, because you have these two different issues. I'm saying that 2504 doesn't apply at all, but then I'm also having to make these alternative arguments based on what would happen if it did apply. But the first part of 2504 deals with the release of one of two or more persons liable in tort, you know, for the same injury. And, you know, the next paragraph would say it doesn't discharge any of the other tortfeasors from liability. You know, well, if the hospital's not a tortfeasor, then, but the doctor's being released from liability, you know, how does it ever apply anyway? I mean, the problem is that I don't think the drafters were thinking of the distinction that we're making here regarding talking about people jointly liable in tort in the opening paragraph and then referring to them as tortfeasors in the latter. Because I would say a tortfeasor is someone who's liable in tort. I mean, there's a judgment. If this case went to trial, there would be a judgment and a jury found that my client was at fault. There would be a judgment in tort against Walgreens. You know, if they found that my client did some sort of actionable negligence, then they would be liable in tort. If you want to treat them different or somehow say that distinction is important, well, then there shouldn't be the vicarious liability period. They're both liable in tort. No Arizona case has ever made the distinction that this person's more liable or less liable, you know, other than back, you know, when there were all those cases on the busy bee doctrine. But you know, as it relates to this particular situation of a principal being liable for the torts of his agent, that distinction has never been made. And it all kind of boils down to the fact that I think that the DeGraff case, you know, was clear on this, and it has been cited in other decisions for the same proposition. I put it, you know, those cites are in the reply brief. The Mann case mentions that it runs the other way. You know, and so I think we're at a situation where the cases say what the law is. They haven't applied it to this factual situation, but what they're basically asking you to do is say the law is not what the court has on more than one occasion said that it is.
I hear you say that 2504 doesn't apply, number one, because there's no release. Number two, because there's a judgment with prejudice. But what I also, and now do I also understand you to say that, which is a fair point, that it doesn't apply in the first instance, because even though it may normally apply in cases of joint and several liability, law and maybe wigs, you can tease out of those cases that even though a vicarious liability is excluded from comparative fault, it's not really a joint tortfeasor situation. Is that your argument?
Correct. I mean, law and wigs both, you know, specifically said it.
Well,
I mean, the Wiggs case said it's talking about 2506, but it says the quoted language from 2506 just makes express that which is implicit. The statute does not affect the doctrine of vicarious liability. In law, citing to DeGraff, they said, we also note that the Arizona courts have discussed with apparent approval, the pertinent principles from DeGraff in cases decided after the enactment of UCADA. And what I'm saying is the court has basically said the vicarious liability rules as set forth in DeGraff still apply post-UCADA, and all that the trial court did in this case was grant my motion based on the principles in DeGraff and its progeny that all say it runs both ways, even though the court's never specifically been dealt with that factual situation. But that doesn't mean the law isn't what the court has exactly said it is.
What case post-DeGraff in Arizona says that? It goes both ways? Hey, man, is that in there? I'm not remembering that.
Yes, in both. In man, the court said, the Supreme Court of Arizona has declared it is, of course, an elementary rule of law that liability of joint tortfeasors is joint and several, and that the release of one releases all. And man was a vicarious liability case. So when they're saying it, it's saying that the release of one releases them all, even the release, not even dealing with the dismissal with prejudice. And in the industrial park case, the court said where a judgment is in favor of the principal, a judgment is res judicata in an action against the agent, a derivative responsibility being present. And that was in 76. The Mann case was, a federal case from 2006. So the court has said over and over again, I understand it's in dicta. I understand it's not the same factual situation, but the rule is what it is.
And if you read 2504 just on its face, that would, you're right, that would fly in the face of law and the many other cases that hold, as we all know, if you really make a mistake if you release the employee, because
Right.
you are releasing the hospital when you do that.
Yes. And I think that bellies the point of, and this was pointed out, I don't want to harp on it too much, but as it relates to the amicus argument, a lot of the policy reasons that are given for why this court should overturn the trial court, just like when we were talking about 2504, they would apply to the other situation that this court does all the time. The court favors settlement. Well, if that's true, then why shouldn't the agent get to settle and you still have an action against, the principal? The idea that if someone's not meaning to dismiss it, then it shouldn't happen. Well, then why in law and in Torres and in the cases where the agents are dismissed, well, then why does the principal get to get out in those cases? If those policy justifications are sufficient, then they would have been sufficient for this concept as it relates the other way. And so I think it all just boils down to this case is governed by DeGraff and its progeny. And I know this case is, this court's recently noted that maybe the Supreme Court needs to review what it did in DeGraff, but that hasn't happened, and we're stuck with the law as it is. And the law as it is that the dismissal of either a principal or an agent on a ground, not all grounds, not any grounds, on a ground, equally applicable to both, is dispositive as to the other party. And I think one way to look at that, to make that point more clear, if you had an employee who was sued both for negligence, and let's say he also was sued for battery in connection with the same incident, let's say it was a car wreck where arguably, he did it on purpose. Well, if you settled with the agent for both of those claims, no principal would come in, it would be res judicata on the action against the principal for the vicarious liability for the negligence part of that claim. But if what they're saying is correct, then when you have those multiple claims, some of which may not be vicarious against the agent, then that settlement wouldn't be binding on the principal. And there's no case that supports either way. I just think it's an easier way to look at it when you consider the multiple claims being brought against an agent as to why that would still be, applicable to dismiss the principal, as opposed to the situation here where we have multiple claims against the principal as opposed to the singular claim against the agent. It's like you said earlier, I don't care that there's two different claims, you know.
I didn't say that.
Well,
I was asking a question at that.
I understand. And so, as to the indemnity argument that was brought up by the amicus, I don't believe it's true that indemnity works in the exact way that he's saying in Arizona. I believe there are cases when an employer has a right of action for indemnity against his employee, and there's cases where an employee has a right of action against his employer. It's based on the nature of the conduct, and Arizona follows the restatement on this point, which basically ends up making it a purely equitable issue that the principal owes the indemnity if the principal ought to owe it. That's what the restatement says. And so in a situation similar to this, if you have a principal that is vicariously liable for the other's acts, let's say it's a pure independent contractor, not a non-delegable duty, but the principal retains control and tells him exactly how to do his job.
That's different.
Okay, well, in this case, if Walgreens told my client specifically what it wanted him to do, and he did it to a T, did exactly what they said, put whatever signs up wherever they said to put them, he could still be sued for negligence for a slip and fall. But in that situation, the cases that have interpreted the restatement would say that his employer owes him indemnity because it is a loss that ought to be owed by the principal because all that he did is exactly what he was told to do by the party who happens to also be vicariously liable for his actions. So I don't think the indemnity action or that this claim or concept carries weight due to the fact that I believe in Arizona it's purely equitable as to when indemnity flows which way from an employer-employee situation, which is essentially what this becomes because of the non-delegable duty. I've only got about a minute left, so if you all have any other questions.
I'm out.
Okay.
Thank you, counsel.
Well, thank you, Your Honor. I appreciate your time.
Thank you. Mr. Altus.
Thank you, Your Honors. Very quickly, with respect to whether law says that 2504 doesn't apply to vicarious liability claims, the purpose of 2504 is to apply to vicarious liability claims. What law says is that UCADA doesn't change what previously had been vicarious liability claims into apportionment claims. That's the proposition that law stands for, not that 2504 doesn't create this structure for how to deal with a resolution in joint and several liability cases. With respect to the indemnity issue that counsel raised, the distinction doesn't have to do with vicarious liability cases in the restatement. It has to do with situations where an agent is making representations authorized by their principal and the third party relies on that. And then lastly, I just want to point out that Appellee's argument in the trial court's decision requires the elevation of form over substance. That's fundamentally the problem here. You can dismiss without prejudice. You can't dismiss with prejudice, even though with a release they have the same effect. That's what the argument leaves us. Thank you, Your Honor.
counsel. Mr. Abney, give us a pause while our bailiff loads up the timer for you. Thank you. Mr. Abney.
Amicus talked about how 2504 would be apply in a vicarious liability case, and that sounds reasonable to me, but also apply in a direct liability case, which is what we have here. We have direct liability on the part of Walgreens, failure to warn customers, failure to keep the premises in a safe condition, negligent hiring, training, and supervision, failure to discover dangers. Those are all direct liability claims. So either vicariously or directly, 2504 should apply. I enjoyed your question about could the release be the same as the dismissal with prejudice be the same as the release. I'd love to say yes, but I'm not quite sure if you look at the statutory language if that would work. The reason it says if a release or a covenant not to sue or not to enforce judgment is given in good faith. So I think that there has to be the parties giving this in good faith and not the court. But I do believe that the judgment with dismissal or judgment without dismissal is simply a memorialization or the outcome of a release. I woke up this morning with my usual, out of my usual pre-argument nightmare, with this phrase running in my face: the release of a one joint tortfeasor releases all. And I thought, oh my God. So I leaped to Westlaw and looked this up. And there's this delightful opinion, Adams versus Dion, that Justice Lorna Lockwood wrote in 1973. Adams versus Dion, 109 Arizona 308. And it threw that out and said that adopted the restatement second 885, which says a valid release of one tortfeasor does not discharge others liable for the same harm unless it is agreed that it shall do so, which makes sense. And the reason it's delightful, it quotes this 1923 Law Review article by Dean Wigmore called Diversities de la Ley. And I thought, whoa, that's great, but it probably should be Las Diversidades de la Ley. But whatever language he was trying to use, it talks about the old obnoxious friend, which was this old doctrine. If you release one joint tortfeasor, you've released all of them, and it makes fun of it. It's delightful reading. And it says that one of the things that the courts had been trying to do, even as far as 1923, was to get rid of the technical ways that lawyers have been using to try to avoid that doctrine that a release of one joint tortfeasor releases all. And one of the ways they do that is to not call it a release. Instead of giving a release, they will give a covenant not to sue, which is not a release, or they'll give a covenant not to enforce a judgment, which is not a release. So 122504 is really trying to address the three ways that the common law had allowed a defendant to escape paying money. One was the release, where you not only not pay money, you're not liable. There's no adjudication liability. You're gone. You're innocent. But the other two ways are to prevent having to pay any money. And 122504 was really trying to be very broad and universal in what it was doing. It says these are the three ways that the parties can get rid of a case and make sure the defendant doesn't have to pay any money. And it doesn't matter what way it is, the effect of that is that you don't discharge the other tortfeasors, but there's got to be some sort of adjustment in the damages. Just a couple more comments. One is de Graaf and law, and all the de Graaf cases, as far as our situation, are dicta. They weren't dealing with our situation. So I would ask the court to keep that in mind. And if I can remember the other point, I will say it. Oh, and I wrote this down before your question on the same subject. Is dismissal with prejudice is a judgment on the merits of Walgreens liability, and that's what it was about. Walgreens liability is out the door, and that's the judgment is solely on Walgreens liabilities. Walgreens, you are not vicariously liable. Walgreens, you are not directly liable. But it's not an adjudication on the merits of what the agent was doing in slopping water on the floor and letting somebody slip in that water. Are there any questions?
No.
As always, it's been a great pleasure. Thank you very much.
Thank you, counsel. We will take this matter under advisement. Thank you all for your presentations and for your briefs. We appreciate it. Written decision will issue in due course. We stand adjourned.